This is Stephen Leskin, and I'd like to welcome you to Oregon Divorce School. Tonight's topic is negotiating assets and liabilities in an Oregon divorce. I do these seminars twice a month, and my hope and my goal is to give people enough information to uh, understand the divorce process and uh, hopefully reduce some stress and get a better result with their spouse uh, going forward. I've been a divorce attorney in Oregon since 1992. Uh, anyways, let's start with the agenda. So tonight's agenda is meet Stephen Leskin. We'll start with that, and then we'll get into what is marital debt. If we're going to discuss assets and liabilities, let's know what both of those terms mean. Uh, so we'll start with what is marital debt? What's an asset? What is the legal standard in Oregon to divide assets and liabilities, valuing assets, and lastly, how to negotiate, or at least think about how to negotiate. Now we'll talk about me. So, my name is Stephen Leskin. I've been an attorney in Portland since 1992. Been practicing divorce law since about 2000. Um, I am an arbitrator and a mediator, and feel free to look at my website or shoot me an email. I don't take questions during the webinar. I get distracted and I get sideways when somebody sends me a question, but I do welcome questions. Uh, if you've watched the webinar and have something that you want to ask me, please shoot me an email or give me a call. I'm more than happy to go through that with people. It's just a little distracting for me to do it online. All right, so let's get into it. Marital debt. Uh, so there's I'm going to make a distinction between debt in the marriage and debt in a divorce because they're two very different things. And I'm going to start with um, ORS Chapter 108, which is the chapter that governs relationships between spouses. And this is not exactly on point for divorce, and you'll see why as we work through it. But I think this is important information in any event that people generally don't know, including a lot of attorneys, but it's still crucial knowledge, adult knowledge that we should have about our relationships with our spouses in general. So I'm going to start with, and I'm just going to walk through a couple of the four um, sections of the statute that I think are the most important dealing with debt. Uh, ORS 108020 is non-liability for other spouse's obligations. So, in a marriage, neither spouse is liable for the debts or liabilities of the other spouse incurred before marriage. So, somebody comes to the marriage with $50,000, the other spouse cannot get sued for that during the marriage uh, or during a divorce. A spouse in a marriage is not liable for the separate debts of the other spouse, and the rent or income of property owned by either spouse is not liable for the separate debt of the other spouse. So that's really a terribly worded statute. And there's one qualification which I didn't read, which I will get to in a second. So uh, this is saying that spouses are not responsible for one another's debt. And this is actually kind of interesting because this statute actually occurs in the Oregon Constitution protecting women. So I suspect back in the 1850s, there were well-to-do women, and men were marrying them and then saddling them with their debt. And it must have been such a issue or such a common thing that it actually made its way into the Oregon Constitution. So uh, this statute is neutral, but in the Constitution, it's protection for women, right? So um, the general rule is that spouses are not liable for one another's debt incurred during a marriage, except, and this is the qualification, and it's a huge qualification, uh, except for expenses related to the family, and we're going to cover that in the next section. But the legislature says that um, spouses aren't liable for one another's debts, except if it's connected to the family, which covers just about everything. So the exception swallows the rule, right? Um, there. Let's get to let's keep moving on. And we'll come the important um, driving, and he runs somebody over. Can the spouse be sued? Can the wife be sued for husband's negligent conduct? No question that husband, let's just say, no question that husband is negligent, run somebody over, and we don't have to discuss insurance issues here. We're only curious about whether the injured person has a claim against the wife. Clearly, the injured person has a claim against the husband, but can the injured person also sue the wife? And the answer to that under 108030 is no. Uh, the spouse is not liable for the other spouse's tortious or civil um, liabilities. Um, the statute uses the word civil for all civil injuries committed by a spouse in a marriage. So this is drawing this distinction between criminal and civil. I presume that's what that means. A spouse would not have um, liability for their spouse's criminal conduct unless they were participating in it. But this is specifying that um, there's no liability for civil injuries. I would question whether or not that also extends to contracts or if injuries is limited to um, what lawyers call tortious conduct, like an assault or a car accident, something where the other person had no, um, where there was a injury caused by a person is generally tortious conduct. The qualifier to this is that there's no liability for the uh, conduct of the other spouse. But let's do a little supposing here. Let's suppose that husband and wife were it was a beautiful sunny spring afternoon, and husband and wife were sitting out at at the porch having a couple of drinks, and husband takes the car and um, then hits somebody. Does that injured person have a claim then against the wife? The answer to that is yes, because wife had some responsibility in providing alcohol to somebody who was apparently impaired, who then got into an accident. So wife could have, in that circumstance, wife could have her own liability for her own conduct. And um, the language in the statute is except where the spouses would be jointly responsible uh, um, for each other if the marriage did not exist. So somebody participates in the injury to somebody else, then they're on the hook. But it's same as if they weren't married. So it's still vicarious or um, what's the other word? I'm blanking on it at the moment, but it's still like agency liability. All right, so let's get to the big one. ORS 108040. And 108040 says that the expenses of the family and the education of the minor children are chargeable upon the property of both spouses in a marriage who are parents of the minor children or either of them or in relation thereof, they may, they may be sued jointly or separately. So that sounds like it talks about like just kids, but the expenses of the family is one clause here. And expenses of the family is a defined term, and it includes only expenses for the benefit of a member of the family. And so that is extraordinarily broad language, even though it starts with only includes only expenses incurred for the benefit of a member of the family. So um, if it's a nuclear family of four, and the child is running up bills, parents are responsible for that. If the spouse runs up bills for themselves, the family, either spouse can be sued for those expenses. Family, I'll just round this out. Family means the spouses in marriage and the minor children of the spouses. So it's not, uncles and aunts and cousins. It's just the nuclear, what we, I guess, used to think of as the nuclear family. Uh, can stand, um, can be responsible to a third party for debt incurred. Um, the time that ends, so that does not last in perpetuity. That lasts as long as the couple is together. Once they separate, the liabilities uh, are not shared. So that's usually defined as the intent, as at the time that the parties intend not to stay together as a family. So the date of separation become in a divorce becomes very, very, very important. I've certainly had cases over the years where a spouse will go up and they'll run up a credit card bill thinking they're getting after they leave, thinking that, well, I'm going to stick it to my spouse. And then they come to find out that no, it's still theirs. They still have that responsibility. Sometimes the debt may be in the form of like furnishing a house. That's a little bit different because there may be um, equity in the property and the furnishings at the home that can be paid, that the spouse has a right to, and they'll get some money for that, and then they can pay it. But anything that occurs after the date of separation is that person's own responsibility. Um, and let's push forward to 108050. So this is interesting. Non-liability of spouse's property for other spouse's obligations. And this goes back to the 108020. It's almost it's a little bit different statute, but it speaks to the same thing that the property of every spouse in marriage acquired at the time of marriage or afterwards, real or personal, acquired by the spouses during their own labor, shall not be subject to the debts or contracts of the other spouse. So this actually goes to like collections. So like uh, the husband gets sued, bad debt. The creditor cannot go after the spouse's um, the spouse's property, right, or whatever they may have a pecuniary right to. So, uh, in a marriage, we're not at the point of talking about divorce yet, but in a marriage, a third party cannot recover a spouse's property to satisfy a debt. So, um, I'm going to interject a little commentary here. I rather like um, these statutes. These statutes, I think, give independence to women. They provide that the spouse's properties and rights during the marriage, uh, maybe a married couple, but they still have full rights and agency during the marriage, and that they're not subject to the spouse's bad behavior, right? So, as an example, women can be very successful or moderately successful, and the husband um, is not or is irresponsible. Creditors cannot come after them um, for their own property, except if an expense, right? So a creditor can come after somebody for an expense incurred during the marriage for the benefit of the family, but they cannot take um, um, a spouse's property to satisfy that. So um, the I think it turns out that the Oregon law is very protective of women and giving both partners equal rights and equal protections. All right, so let's get into uh, what is an asset. And just to be clear, the reason we're talking about this is that we need to know what can be on the table when we're talking about property and debt in a divorce, right? So that's we're defining our terms before we get to the table. So the big chap, the chapter in the ORS, in the Oregon Revised Statutes, that governs divorces in Oregon is Chapter 107. And if you want to read it, you can go to Google and type in ORS 107, and that chapter will appear. And excuse me, within that chapter, there's a section 107, 105, and it's called Provisions of Judgment. And 105F uh, deals with division of personal and real property. So, personal property is a car. It's the mug on my desk. It's the desk. Real property can be either real estate or a home on, or and the home on that real property. So, real property is anything um, attached to the earth. Uh, there are two types of property. There's titled property and untitled property. And the reason this is important is it is not so much for like a conceptual understanding, but it's for the mechanical transfer of property in a divorce. So I'm just going to take a second here just to detour and explain the difference between titled and untitled property. So the money in my wallet is not titled. It belongs to me because it's in my wallet. If it fell out of my wallet and fell on the street, it would belong to the person who found it. A car, on the other hand, or a boat or a snowmobile or a plane is titled. And it doesn't matter who has possession of um, that boat or car or snowmobile or plane. It's what the title says. It's who the title says is the owner, right? So uh, personal property, like the money in my wallet, like if I give you the money in my wallet, it's yours. If I give you the mug on my desk, it's yours. If I give you the desk, it's yours. Whether I sell it or however it comes about, it could be a gift, it could be sold, it could be found, abandoned and found. Those are it becomes the recipient's property. Titled property is only transferred via a transfer of the title. So you have to sign off on the car title. You have to sign off on the snowmobile title or the airplane. Um, and so if you're incident to divorce, you want to make sure you know if you're dealing with uh, titled property or untitled property. Uh, as I'm talking about this, there's other types of properties too that I should mention, which I didn't put on the screen. I didn't think about it until I was just running through it in my mind. One is like intellectual property. So, for example, supposing you write a song and the song is copyrighted, you have the right to that property. And in a divorce, that copyright has value and it becomes part of the divorce. Cryptocurrency is the same thing. It has value in a straight. It's obviously a species of titled property. It doesn't transfer via um, title, but it transfers through digital transfer. It's bought and sold through digital transfer, and the record of the transfer is the proof of ownership. So those are also different types of property. Um, there's all kinds of intellectual property. Intellectual property can be a patent, it can be a copyright, it can be a trademark. Intellectual property can also be a photograph. And the thing that's interesting about a photograph, not necessarily a painting, but um, a photograph, the owner of a photograph may own the film or the paper, but not the image. So those things can be split. It's a little bit nonsensical, but the copyright holder of a photograph owns the image, not the photograph. Strange but true. The other couple of things to know about property is that property acquired prior to marriage. You buy a house, couples living in it, uh, that may be part of the marital estate, or it may not. And the court will go through analysis of property that's owned prior to marriage, uh, and decide whether or not that becomes part of the divorce, whether the value of that property becomes part of the divorce, or what portion of the appreciation of that property becomes part of the divorce. And that analysis is called a Kunze, Kunze, analysis, and it's deeper and more complex than I'm going to get into tonight. But it's something that occurs in almost every divorce case where there's uh, premarital property. Um, and then there's also property acquired by inheritance. Uh, and if marriage, the general rule is that marriage, property acquired by marriage during a divorce, as long as it's um, bequeathed to one partner and not both, and it's not been commingled in the marital estate, meaning a spouse's name has not been added to the title. Uh, that property stays separate. Uh, there's some dispute about this, um, but some judges will look at uh, inherited properties, part of the marital estate, and still make um, adjustments for the value of that property. So if there's only one asset in the marital estate, the judge may um, give more assets. Let's say it like this: there's one asset, but cash. The judge may say, "I'm going to give more cash to the other party because you're coming away with a separate property," which doesn't really make any sense to me. If you've got that separate property, it's separate property, but it's still considered part of the marital estate. Um, Go figure. Um, Standards. We're going to talk about standards now. So before negotiating um, the division of assets and liabilities, you have to know in a divorce, you have to know how the court is going to view the division of the property. And uh, if two people have wildly different views of like what the standards are, they're not going to get a resolution. If both parties are on the same page and understand the law, they're more likely to come to an agreement. And so um, it's important to understand what how a court will look at dividing uh, property. And usually, when we're talking like this, we're talking about houses or other assets of value. We're not so much talking about the cars or the furniture, even though this applies to that. We're looking at like the bigger assets, like the appreciation in a home. So uh, going back to ORS 107, 105, and this is in section F, the statute reads, and this is what was written by the legislature, uh, division of real or personal property as may be just and proper in all the circumstances. So it's inevitable. It is just inevitable that a husband will look at just and property in all the circumstances one way, and the wife will look at just and proper in all the circumstances another way. How the legislature, I should say, how the courts deal with this is by creating an analysis to decide how the property will be, how to interpret this phrase. Uh, there's one other presumption. There is a presumption written into this statute that both parties have equally contributed to the acquisition of assets during the marriage. This is a rebuttable presumption, but it is a high standard to overcome. So, for example, it used to be that men would say, "Well, I paid for the mortgage for 30 years and wife was just a homemaker." That argument carries no weight under the statute, right? Wife contributed in her way to the house, and that has value, or I should say, to the equity in the house, and that has value. So, The times when the presumption is defeated are um, the spouse has taken himself out of the marriage, right? Or the parties have maintained completely separate assets and liabilities throughout the marriage. So um, is and or like for example, the times I've won these cases on this point, they filed separate tax returns, they had separate bank accounts, they had separate savings accounts. There was no financial planning, there was no estate planning. Uh, One spouse did not name the other spouse as a beneficiary in a life uh, insurance policy, right? These are two people who are living together, and that's about it. And the courts will say, okay, well, that can rebut the presumption of equal contribution. The other things that the court look at are the intent of the parties and the duration of the marriage. Uh, and so the way lawyers typically explain this is that the longer parties are married, the more equitably, meaning evenly, the marital estate will be divided. Almost to the point of after we establish the values and aggregate them, total them all up, we're going to divide that in two, and each party is going to come away with the same amount, right? So if both parties own altogether $100,000 in assets, uh, net assets after liabilities, uh, uh, each is going to come away with 50,000. The courts will look at the duration of the marriage and the intent of the parties. And lawyers will further say that um, in a short marriage, the courts will try to put people back into the position they were before the marriage. And what that usually means is that suppose um, husband sells home to buy new home with wife, and wife is going to keep the home. And husband put $50,000 into the new home. Husband will get that $50,000 back, right? The intent of the parties was to live together, to invest together, um, uh, and even if in a short marriage like that, the court will try to put the husband back in the position that they were in. Otherwise, it would just be an unjust situation for her, for the wife in that situation, to um, keep um, his contribution to the new home. So intent and duration of parties are factors that are important for the courts in deciding which how to divide the property, um, and they work together in that, and that's where that's so supposing it's a long marriage, like like typical family, husband and wife, and they both work, and 30 years later, they get they decide to get divorced. Situation like that, the courts, it's mathematical. So maybe you have to value things, but it's going to be pretty much mathematical. All of the assets would be valued, and then liabilities subtracted out, and then what's remained is divided equally between the parties. And so one of the lawyers may come back and say, well, we're going to try to rebut the presumption of equal contribution. It's true that they lived together for 30 years, but wife lived outside the house. Wife had, a boyfriend that she lived with. It's not important that she had a boyfriend, but that she took herself out of the house and was living with the boyfriend and wasn't making any contribution for 25 years. So the intent of the parties in that situation changes, and you could say we we are going to attempt to rebut the presumption of contribution. And in those types of cases, certainly the attorneys and the parties are not going to see eye to eye, and um, uh, that would be a case where, for example, the court does not divide the assets and liabilities equally or evenly. So uh, we're going to talk. I mentioned valuing property, and this is a important step of any negotiation, is knowing how much something is worth. And central to that is the concept of equity in terms of property. Equity is always equity is always market value minus what's owing. So, for example, if a house has a market value, meaning it could be sold tomorrow, and this is what it would bring, of $300,000, and there was a $250,000 loan on it, the equity would be $50,000. And that's the part that's divided, right? So equity could apply to a car, it could apply to other investments, but equity is the amount that's valued. When a couple is going through a divorce in Oregon and in most of the counties, they're required to produce something called an assets and liabilities statement. And the assets and liability statement lists out all of the assets and their values for both parties. It aggregates that. So you have one figure that says the couple is worth X number of dollars, and then it divides it into and then makes adjustment for who owns what. So if the equity is in the house is $50,000 and there's no argument to rebut the presumption of equal contribution, uh, and husband has $10,000 in the bank account, that $25,000 is going to be divided, and wife doesn't have anything. 15,000 to husband, 35 to wife. So they each come out with, um, uh, in that case, the gross value would have been 65. So 50,000 for the car, 15 for the husband's bank account. So there's total 65. Husband already has 15. So 25 to each, 15 to husband. So 40 to wife and 25 to husband. And that gets them each to um, half of $65,000. I hope I said that clearly. I'm kind of thinking I didn't. In any event, I'll push on. So the question becomes then how to value property. And so let's talk about like different types of property. Um, there's homes, and obviously you can go to an appraisal for a home. Uh, and you can also obviously use online services like Zillow or Redfin. Uh, what I do when I want a ballpark figure is I will average Zillow and Redfin and one of the other sites so that I have several values uh, because they no none of them are really particularly they're reasonably accurate. They tend to run a little high, uh, but you'll at least have three different data points. Uh, but an appraisal, a market appraisal, is the gold standard for evaluating um, real property generally. Uh, uh, it's not, and so uh, the appraiser may or may not account for like repairs that need to be made, or the addition to the house, or something like that, or the new roof. And then it comes up to the party to say, well, I don't think the appraisal is accurate because of the we put a new roof on last year, and that adds value to the house. Or the basement flooded, and um, there's still repairs that need to be made to the plumbing in the house, and so that will lower the value. So while an appraisal is a good starting point, it still could be parties could still dispute what the final market value is. And of course, not to put too fine a point on it, but you don't really know market value until something is sold, right? So a realtor can value a home at $1 million, but it sells for 1.3. Well, 1.3 is the market value. The appraisal was just that. It was an estimate of what the market value was. So you don't really know market value until a property sells, but an appraisal is a pretty good approximation of what market value is or should be. Um, Things that are easy to value are bank statements or account statements uh, for retirement accounts. If it's uh, an IRA, it's easy. It's just this is how much is in the IRA account. If it's a pension or 401k, it becomes more confusing, and generally you have to bring in somebody who understands these financial instruments to get a value, so you can figure out how to divide it later. Uh, you can also value property via publications. So, for example, if you had a coin collection and wanted to value that, there are books and resources that can value those. There are technical, legal um, things you have to do to get that before a judge, but those are also sources um, of value. And lastly, and least reliably, is personal opinion. And judges hate this. So parties have, um, a house full of furniture, and both spouses are entitled to half the value. How do you value realistically? How do you value the kitchen table or the silverware or um, whatever else is out there in the home? The tools. So uh, a homeowner can give an opinion of the value of their tools. If there's a shovel in my garage that's probably been there for 20 years. What's that worth? $10? Who knows? Um, but my opinion of what that value is carries some weight with the court. Excuse me. Um, but if I was like a personal tool dealer, like if I bought and sold used tools, then it would have more value, and maybe I could qualify as an expert and give an opinion about what the actual market value is of just household tools, for example. All right, final chapter: how to negotiate. So, um, I think one of the starting points for negotiation is uh, knowing what happens if your negotiations fail. Is the cost of a failed negotiation going to trial? Is it um, a lawsuit? Is it you're walking away from in your mind? You're walking away from the the transaction. So the starting point is to figure out like what are the consequences because that tells you how hard you're going to push. So first rule is know what happens if your negotiations fail. Uh, Second rule to me is know the rules. Like we talked a little bit about Oregon law and how a judge will use ORS 107, 105F in allocating who's going to get the value of which property. But there are other rules too. Um, and you have to know you should know like both the substantive and procedural rules. Like for an example of a procedural rule is sometimes when I negotiate with somebody, I'll say, once an item goes on the term sheet, it's done, right? We're done negotiating that. If it doesn't go on the term sheet, it's still open for discussion. Another rule might be we have no agreement until everything is agreed. That's another rule. So maybe you get 90% of the way there, and the last item you can't agree on, you don't have an agreement, right? So those are kinds of things that you want to think about before you start negotiation. One of the most important rules is have a comprehensive plan. Look at everything as a whole and figure out where you want to be. If there is a lot of debt, how is the debt going to get paid? Do you need spousal support? Do you need an income producing asset? Right? How are you going to get what you need? How are you going to fulfill your interest in the negotiation? So uh, you can't really negotiate like, for example, like there's a car with $12,000 in um, car loan, right? But there's not enough money to pay that. Well, what are you going to do? You could ask for spousal support, or another asset. Maybe you're going to ask for more in the retirement plan, right? So have a plan, know what you need, think comprehensive about how the settlement will look at the end before you even start negotiating. Um, so um, So the two examples I gave, those are the two examples I gave. Like, do you need spouse support to pay debt, right? Or do you need an asset to generate income? So income to live on. So maybe there's a rental unit. Maybe a family owns a rental unit that produces income. Maybe you can take that in lieu of spousal support. So be thinking comprehensively and flexibly how to get all the pieces to come together. Uh, so I mentioned this a while ago. Know the rules. Are you negotiating a global settlement where everything has to be done, or are you negotiating once something is done, once you come to agreement on something, it's considered resolved. Not lastly, but next, know your red lines. Like, if you're like going to be paying, like you're going to be paying spousal support. Like you're the income earner in the family, and you know you're going to be paying income. What is the most you can pay, right? You know that like if you have, an extra, you know that you can pay 2,000 a month. You have to know that, and be able to convey like why you cannot go beyond this, right? 2,500 is a month. 2,500. There's no way you're not going to have enough to eat, to live on. Uh, but be prepared to. These are my income numbers. Here's my bank account. You can see that I generate $3,000 a month in income. There's no way I can pay $2,000 for spousal support, right? So know your red lines and figure out like how you're going to substantiate those, because it's just typical in uh, particularly in a spousal support context. Oh, I can't pay more than X number of dollars. Well, of course, everybody says that, but the stronger argument, the stronger way to do it is to be able to substantiate that after this month, it's cutting into my living and food expenses or whatever it is. Um, Another rule to know is, you know, are you in a situation where you can consult a third party during the negotiations? Maybe there's a general rule that, the parties are here and they're going to do it themselves and they can't reach out to somebody during the negotiations. Sometimes you have to speak to an accountant or you have to speak to a tax preparer or a finance guy. Sometimes that's just part of it. But you want to make sure that like if like you're like in the same room negotiating, that you have that ability to reach out. Um, think about where you want to start to get to where you want to be. So if you want that $2,000 a month in spousal support, you're not going to say, I need $2,000 a month in spousal support. You're going to say, I need $25,000 in spousal support. And then that gives the other side something to wear you down, right? So you can say, okay, all right, I'll give up some, you give up some. And that way you meet closer to where you want to be. And who knows, maybe you'll get lucky and they'll say, 25, that's fine. 2,500, that's fine. I can live with that. But never start with like what your ultimate is. So the question then becomes, well, how much should I start with? Uh, I don't know what other people do, but usually um, I just start with like about a third or 25%. And, I'm not going to make a big drop. Like I know where my red lines are. And I was like, no, I can't. I've given some up. I can't go further than this. So um, you're gonna make some. You're gonna chop some of this. You're gonna chop some of it down, certainly. But you're not gonna go. Okay, you're not gonna. If you start at, supposing you start at 6,000, you end up at 2,000. That undermines your credibility for everything else, right? If you give so much like away, that tells me how the rest of the negotiation is going to go, right? So a sophisticated negotiator won't start with a huge amount. They'll start, kind of where they want to be, and then give or take, um, uh, but not huge amounts. That's the way I do it. Other people may have different ideas. Um, so I used to settle. I used to do a lot of personal injury work, and um, you had like a minor car accident, which realistically would settle for pain and suffering for $5,000. If you started at 100, you'd get $1,000 offer, because the insurance company knows that they have to start really low, uh, and not at 4,000. They could put out 4,000, say take it or leave it. We're not going to screw with this. This is so out of proportion. So part of setting your negotiating demands also involves your credibility. And then lastly, know what your partner wants. Know what you think about. Like, what is your uh, what are your partner's interests? So you have to listen and think and get a sense of like what your partner needs are and how you're going to meet them. I usually say that um, if we don't um, if we can't get an agreement, then I haven't shown you that our interests are allied, right? So know where your partner's interests are, and so you can move to a space of aligning your interests and theirs. And maybe that takes some creativity. Maybe it's just a question of money. But uh, what ultimately you're doing in a negotiation is showing the other side how your interests and their interests align on your terms. So think about that, and that requires some sensitivity, some thinking, some listening. Uh, if it's a marriage and you know your partner, you'll have some insight into what that person wants, and you can go from there. All right. That is the presentation. So let's just go through a couple of um, uh, final thoughts. Most important, be prepared. Know the rules. Know the big rules, that the standards and the little rules. Um, have a plan. Don't go in and shoot from the hip. Have a comprehensive plan uh, so that particularly in a divorce, so that all the pieces fit together. That you know what the debts are, you know what the income is, you know what the liabilities are, and how the court might look at dividing them. Don't go in without giving some thought to where you're going to start and where you want to go. Know what your partner wants, right? Think about what your partner needs and what their interests are, and then in a non-self-serving, non um, delusional way, think about how you can show your partner that your interests and their interests align. And a lot of times, the word I'm looking for is wishful thinking. A lot of times, I'll hear partners say, "Well, I'm going to show my the husband in his mind is thinking, I'm going to show her why she doesn't need spousal support. Well, she's 60 years old and has never worked in her life and has bad health. Of course, she's going to get spousal support. And husband has worked himself into a position that I know that she shouldn't have spousal support because she wants me to do well or be happy or whatever. That's delusional thinking, right? There has to be an objective, honest appraisal of how your interests and the other party's interests ally in order to get to a settlement. Sometimes their interest may be the unspoken interest may be, well, we just don't want to go to court. We want to get this settled, and we're both willing to give and take, so we don't go to court. You know, that's great. So think about, and one party has more tolerance for going to court. So um, think about, realistically how you line up your interests and your partner's interests. Know your red lines. Know what you can and can't give, and know that beforehand and come prepared to demonstrate it. It's not enough to walk in and say, "Well, I can't pay anymore," or "There's no more money." You have to be in a position of proving uh, what those red lines are. Every spouse support payment, oh, I don't have enough money. It's going to be, I don't have enough money. Um, or the spouse is, I need so much money, to live the lifestyle I'm comfortable in. And so documenting those things uh, goes, gives you credibility in negotiations and shows the other side that if you do end up in court, uh, this is why I will prevail because I'm documenting what I have, and this will convince the judge that this is the most I can give, or whatever the issue is. And then lastly, and most importantly, and I referred to this once already, know where you have to start to get where you want to go. You're not going to start with your bottom line. You're going to start with maybe 20% or 25% or 30% of your bottom line, not 100%, not 200%. Some, you know, 30% is a good starting place. And stick to your guns. I can't go that much further, or I don't have that much more to give, or I need this because, uh, uh, and be prepared and anticipate what their objections are going to be, right? So know where you have to start to get where you want to be, and part of that's going to be anticipating what the objections are and think about like how you are going to overcome this. So that's it. I hope that was beneficial. And please, if you have questions or comments, please feel free to give me a call, shoot me an email. If you found me through Meetup, please leave a review. The reviews are great. They help people find me. And I think that's about it. Have a good evening. Thank you.